will the new public charge rule impact immigrants? On February the 24th, 2020, the Department of Homeland Security's new public charge came into effect. This rule will now impact all applications to immigrate in the United States, whether the applicant is outside the United States or inside the United States. I'm attorney Raluca Hanea, and I provide immigration, family law, and estate planning services to my clients. And thank you for all your likes, shares, and comments as they help others to see our videos. So what is exactly public charge rule? The public charge is a ground of inadmissibility. So we have talked in another video last year about the different grounds of inadmissibility in the United States. And they are reasons that a person could be denied a green card, visa, or admission to the United States. When we are talking about public charge, an immigrant officer, they must decide whether a person is likely to become dependent on certain government benefits in the future, which would make them a public charge. There are some very important points regarding this rule. This rule mainly impacts those seeking permanent resident status through family member petitions. Another point is that this rule applies to those seeking entry at our borders or those applying for a green card, a lawful permanent residence. Another point is that those who are viewed as likely to become dependent on the government in the future as a public charge, then they are inadmissible. So their application will be denied. There are immigrant categories that are still exempt from this rule, from the public charge rule ground, even if they might be applying for status or a green card. For example, the U visa holders, the T visa holders, asylees, refugees, and a few more categories are exempt. The public charge rule does not apply to the naturalization process. The naturalization process is the process through which a lawful permanent resident applies to become a U.S. citizen. A very important point also is that although the rule takes effect to applications that are postmarked on or after February the 24th, 2020, the rule will take effect immediately to all the applications that are pending with the consulates outside the United States. So that means that even if those applicants file their applications before February the 24th, 2020, they still have to conform to this new rule if their visa interview has not taken place already. How is the new rule changing the public charge test? For at least 2 decades, the use of most public benefits was not a barrier to legal status in the United States. Although it is worth mentioning that most immigrants who are on the path to a green card don't have access to these benefits, or if they do, they are an immigrant category that is exempt from public charge. Nonetheless, this new rule punish receipt of vital health, housing, and nutrition programs. And these programs include federally funded Medicaid, SNAP benefits, also known as food stamps, and Section 8 housing benefits. So in addition, Also, in addition, the new rule direct immigration officers to use their own discretion in making important decisions whether a person can immigrate to the United States. So this makes the process very subjective. This rule will definitely impact green card applicants for low-income families. So what is the definition of public charge under this new rule? So the new rule defines a public charge, a person who is likely to receive any number of public benefits for more than an aggregate of 12 months over any 36 months period of time. So for instance, if an applicant is likely to receive 2 different benefits in 1 month, that counts as 2 months use of benefits. So what are the programs that qualify as public programs under this new rule? The rule definitely expands the list of publicly funded programs that the immigration officers may consider when deciding whether someone is likely to become a public charge in the future. Federally funded Medicaid, the food stamp programs or SNAP, Section 8 housing assistance, and also federally subsidized housing or other local subsidized programs, they can all be used as evidence that the green card or visa applicant is inadmissible under the public charge ground. Also, that goes to cash aids programs such as TANF and SSI, but also any state or local cash assistance program. They can also make an individual inadmissible under the public charge ground. It is very important to know that prior receipt of benefits, so if you apply for these benefits before you apply for your green card or the admission in the United States, is only one factor in the public charge test. So the officer take that into consideration, but it's just only one factor. The rules elaborate on many other factors, and they are now looking at factors such as the applicant's age, health, household size, education, employment and financial resources, as well as English proficiency and medical conditions. So an officer can take all these factors into consideration when they consider someone if they qualify for as a public charge and deny them the application. And since the rule came into effect just last week, there are still a lot of unknowns, and we will try to keep you updated with any new developments. Please call us if you have any questions about your immigration case, because we are always here to help. Thank you for watching, and see you next time.